Good afternoon for those joining in the UK and in Europe, and good morning for those joining from North America. Welcome to the next instalment of Contract Conversations. This is a series of bi-weekly webinars which are being hosted by lawyers from across Mills and Reeve, and we discuss common issues which are faced by people who are operating and drafting English law contracts that arise in contractual disputes. And so the types of things that you need to be aware of. This session is being recorded, so after the end of the session, you should get an email with a recording if you wish to look at it again and the slides. So today we are focusing on governing law and conflict of laws, which sounds very glamorous, but it's not that complicated. But in light of Brexit, it does seem like a good time for a refresher. I'm Sarah Jacobs. I'm a senior associate in the commercial disputes team at Mills and Reeve, and I'm usually based in the London office, although not for a long time now. And I'm joined by Jonathan Christy.
Hi, and I'm an associate in the same team as Sarah, the commercial disputes team, and also based in our London office.
Fantastic. So there is a question and answer function, which I believe is down the bottom of your screens. So you can type in questions as you go. We'll try and deal with as many as we can once we've finished talking, if we've got time permitting. So if we can have the next slide, please, Johnny. Great. So I'm going to start off by just explaining what on earth we're talking about when we're saying governing law and conflict of laws. So the context is, say you enter into a contract with another party and a dispute arising out of that contract. How do you know which law of which country is going to apply? When you've got two UK parties and work being done in the UK, it's not really likely to be an issue. But what if there is an international element? So you're contracting with a party who is based overseas, or the work is to happen overseas. For example, say I enter into a contract with a company that is based in China and we get into a dispute. How do we know whether UK law applies or whether Chinese law applies? And obviously, I mean, I don't know a huge amount about Chinese law myself, but you can imagine that there would be quite different outcomes depending on which law applies. So it can be quite important. So this issue is called the conflict of laws. How do parties deal with it? Well, they do a specific clause in their contracts, which is called a governing law clause. So that's what we're talking about when we're talking about a governing law clause. And there is an example of one on the screen there. And I'll just quickly read through it. It says, this agreement and any dispute or claim, including non-contractual disputes or claims arising out of or in connection with it, or its subject matter or formation, shall be governed by and construed in accordance with the law of England and Wales. So basically that's a clause in the contract that says the parties agree any disputes, any arguments between us, it will be governed by the law of England and Wales. Often a clause like this will go on and talk about another issue, which is called jurisdiction. And that just means who has the ability to deal with a dispute. So is it a court? Which country's courts have that jurisdiction, or is it an arbitration body? And that's called a jurisdiction clause. We're not going to talk about that any further today because that could fill a whole other seminar. But it's just worth bearing in mind that the two often go hand in hand. And it's also worth just noting that it is possible to have a different court from a different country having jurisdiction than the law. So you could technically have Chinese courts having jurisdiction over a contract, but they have to apply the law of England and Wales. It's possible for the parties to agree to that, and courts will often try and give effect to that if that's what the parties want. So the rest of this talk, we're going to be assuming that an English court will be dealing with it, so that they would have jurisdiction to decide which law applies. Okay, so I'm now going to talk about what's the law? How do we decide which law applies in such a dispute? There are different instruments that apply depending on when the contract was entered into. So if the contract was entered into before December 2009, there's an instrument called the Rome Convention. If it was entered into after December 2009, there is another instrument creatively called the Rome I. So they weren't particularly creative with their names, but basically the rules under both are very similar. I'll highlight when there are any differences. The primary rule under both, so no matter when the contract was entered into, is that the contract is governed by the law chosen by the parties. So if you have a governing law clause, like the example on the slide, and you've specified a particular law, the courts will give effect to this. So that means that the easiest way to ensure certainty, and this is what Jonathan's going to touch on later, is to make sure you have one of these clauses so that you're not having a quite legal argument about which law applies. However, not all contracts have these clauses in them. So what happens then? How do we decide? The first thing that a court would do is they will look for an implied choice. So there might not be an express choice like there is in this clause here, but they might look at the contract and say, is it so obvious from the terms of the contract and the circumstances that we can imply a choice on behalf of the parties? So, for example, if you had two English parties contracting the services to be performed in England, the contract was in English, etc., etc., a court might say, okay, they haven't actually written it down in the contract, but it's so obvious here that they meant that English law should apply. It's quite hard to imply clauses into contracts, though, as I'm sure some of you will be aware. So it's not a surefire way. So what if you can't imply a clause? What if it's not so obvious which law applies? Okay, there's then a general rule that the Rome Convention and the Rome I both set out, which is, and bear with me because it sounds complicated, but it's not. It's the law that applies is the law of the country where the characteristic performer has their habitual residence. Characteristic performer of the contract, that's just the person who's doing the performance for which the payment is due, right? So if Jonathan and I are in a contract and he's paying me for my legal services, I'm the characteristic performer because I'm getting paid. Okay, so where's my habitual residence? For a company, that's just where you have your place of central administration. So not very complicated. For a person, it's just where your principal place of business is. So if I'm contracting with Jonathan in my personal capacity, it would just be where my principal place of business is, so the UK. The conventions slightly differ in that the Rome I, which is for contracts entered into after December 2009, is a bit more helpful in that it sets out some specific examples to figure out this question of where the characteristic performer has their habitual residence. So, for example, the Rome I specifically says that if you've got a contract for a sale of goods, then the law that governs the contract is where the seller has their habitual residence, which makes sense, right? Because the seller is the characteristic performer. But generally, that's just the rule. So characteristic performer and where do they have their habitual residence? There is a way to wiggle out of that, though. So if you are in a situation where, for example, you're contracting with a Chinese company and the company is performing in China and you don't have a governing law clause and you don't want Chinese law to apply, what are you going to do? Well, both of these conventions give you an escape route, which is a different law can apply if you can show that the contract is more closely connected with another country. It's a little bit harder under the Rome I, so for contracts entered into after December 2009, but it's broadly the same. situation? Is it more closely connected with another country? An example of this is if you have a chain of contracts. So say I'm contracting with Jonathan, he's based in China, and there's no governing law clause in our contract. Jonathan's the characteristic performer and he's living in China. How do I get out of that? Or say that it's part of a chain of contracts. Say I have multiple different contracts with Johnny. This is just one of them, and all of the other ones have express governing law clauses saying English and where English law applies. I can point to that and say, well, come on, of course, this contract is more closely connected with England and Wales because of the whole chain of contracts here. So that's sort of how it works. So is there an express choice of law? If not, is there an implied choice of law? Probably not. Where does the characteristic performer have their habitual residence? And is the contract more closely connected to the law of another country, and that law should apply? And I should also just say here, once you've figured all of that out, there are some types of law that will always apply, even if the parties have contracted for a different country's law. So for English law, for example, so say Jonathan and I have a contract that's happening in the UK, but we decide that we want Swiss law to apply for some reason, which we are allowed to do. There's certain legislation and English law that will apply to what we're doing no matter what. So for example, the Unfair Contract Terms Act will apply, even though we've decided we want Swiss law to apply. Or, you know, for example, rules on cartels. We can't wiggle out of that by saying another country's laws apply. And in addition, there's some special types of contracts which have additional protection from parties trying to wiggle out of laws applying by choosing a different law. And these are employment contracts, insurance contracts, and consumer contracts. And if you do have any of those and you're trying to do a governing law clause, then I would say you should get some advice to make sure you know what you're signing up for. For example, say I employ Jonathan here in the UK, but again, we agree that the governing law is Swiss law. Because this is an employment contract, Jonathan still has all of his employment rights under the ERA. So he can still complain if he's unfairly dismissed, for example, even though that right might not be available under Swiss law. So that's how it all works. Does Brexit make a difference? Thankfully, after listening to me go on about this for the last 10 minutes, it does not really. The contracts entered into after the end of the transitional period, so contracts entered into from this year onwards, there is a new piece of legislation that applies, which is being colloquially called amongst practitioners UK Rome 1. So now we've got the Rome Convention, Rome 1, and UK Rome 1. Basically, it's just using all the same laws, the same structure that I've just outlined. The only difference is that it's got rid of all the references to the EU, and the English courts in deciding which law applies to those contracts isn't necessarily bound by the European Court of Justice decisions, whereas they might used to have been. So that's how it all works. I'm now going to pass on to Jonathan.
Okay, so Sarah's just set out the basic framework of how the English courts would work out which system of law governs a contract in a scenario where the parties have not nominated one. And although Sarah has made it sound very simple, it can be a very complex issue when more than one system of law might apply, and certainly one which you do not want to get into a dispute about before the real substance of the dispute can be dealt with. So, I mean, as an example, if you have two competing systems of law that might apply to the contract, and one of those jurisdictions' laws limitation period has expired, the debate over which laws apply will be equally hard fought as the rest of the case, because for one party that is tantamount to a strikeout, and so in that scenario, you'd want to be getting advice from lawyers in both jurisdictions to work out how strong your case might be if that law applied. And this dispute, getting extra evidence, advice, will all serve to push up the time and the costs spent on the overall case. And therefore, the last thing anyone wants at the start of a potential dispute is a conflict of laws dispute. So to minimise the uncertainty and the risk of long and costly disputes prior to the main proceedings, it is crucial to make clear that which law governs your contracts. So obviously, the best way this can be done is by inserting a clause stating exactly that. But Sarah mentioned a second ago, it should be noted that parties are generally free to post-contractually nominate a system of law to govern their contract. So if you are to insert a clause, which we'd highly recommend that you do, what elements need to be ticked off for a governing law clause to be valid? So it needs to be 1, in writing, 2, clearly specifying the law of a jurisdiction, and then 3, clear that the parties have both consented to it. Now, these seem like quite simple propositions, but what we often see is number 2 there, the clearly specifying the law. It can create a bit of a hang up. We often see cities nominated, or the law of the USA, the law of the UK as the governing law, and these are just allowing a little bit of inconsistency, a little bit of doubt over exactly which system of law applies. So, for example, in English matters, the clause needs to state law of England and Wales. We have devolved administrations. The US obviously has state law, and therefore you could get into debate about which specific law applies in those other scenarios. It is important to note whether the parties have chosen the law that will govern the contract, as well as the forum that will hear the relevant dispute. So, as Sarah mentioned, a governing law clause is distinct from a jurisdiction clause, and therefore both choices should be separately and clearly stated. So, which system of law are you going to choose when you pick your governing law? And we'd say that the following factors should be considered whilst going about this process. First of all, you want to pick the chosen law wants to offer certainty and the ability to foresee how a dispute in connection with the contract is likely to be determined. So, in other words, do the principles of law and their interpretation favour the parties and the type of transaction? So, for example, English laws are considered particularly suitable for parties in a commercial transaction. And then, secondly, should you match up the chosen law with the law of the country or jurisdiction that the dispute is to be heard in? And so we saw, whilst the jurisdiction and governing law don't need to match, it's really important just to consider the practical elements of this. For example, will the courts be used to interpreting a foreign law? Are you going to have to instruct a foreign lawyer to give evidence? Will that evidence significantly add to the time and costs of the litigation? Are there going to be language considerations? If you have an expert on French law coming to the UK, are they going to need a translator in court? It adds elements to it, adds time, it adds costs, it adds more scope for inconsistency and more dispute. And then, one further consideration is non-contractual obligations. So when you make the choice of governing law, it's very important that non-contractual obligations are also considered. So non-contractual obligations being misrepresentation or negligence, these are claims related to the contract, but not contractual causes of action. And so traditionally, non-contractual claims are governed by the law of the place where the underlying event, harm, or tort takes place. So in cross-border disputes, where a contract might be performed in different countries and where the component factors of the dispute are spread over several countries or jurisdictions, the practical application of this principle can result in uncertainty and confusion about the applicable governing law. So, for example, you could have a harm that has happened in France, again, let's say, but a contract that has not specified non-contractual obligations in the governing law clause, and then you have a situation where two different types of law can be applied to what is likely to be the same same dispute. So as most jurisdictions will accept the party's choice of law in relation to non-contractual disputes, and certainly the EU-based jurisdictions will under different convention called Rome 2, generally it is advised that you choose the governing law of the contract to cover both contractual and non-contractual obligations, and then you won't have the awkward situation of different laws applying to different parts of the same dispute. So to do so, it is recommended that you add wording such as including non-contractual claims, just as simply as that, or all matters arising out of or relating to this agreement in your governing law clause. And if you are agreeing to choose a system of law that is not the same as the legal advice that you're already receiving, we'd recommend seeking that local law advice to ensure that the wording is clear in its meaning and sufficiently broad to govern non-contractual claims to take effect in that jurisdiction. So just a quick summary of our top tips. So you need to have a clear governing law clause. Let's avoid getting into any disputes over everything that Sarah was talking about. If you are planning to choose a system of law that is not a law that you and your legal advisor is used to, get local counsel advice in that jurisdiction or an expert in that system of law, and ensure that the clause allows for non-contractual obligations.
Great, thanks, Jonathan. So we'll now have a look at some of the questions that have come through. Someone's just said they can't see any slides for the topic from Jonathan. That was all on the one slide. We tried to keep it nice and brief, even though he did have some very important points to make. So someone's asked, in terms of governing law, is it English law or the law of England and Wales, and does it matter? Which I think Jonathan touched upon. And you'll see in that governing law clause on the previous slide, if you don't mind going back, Jonathan, it is the law of England and Wales. And it's that point that he was talking about. You want to be quite careful that you're defining it correctly. It's especially, even myself throughout this presentation, I've probably been referring it to it as English law, but technically it should be the law of England and Wales. Someone else has asked, how does it work in a supply chain, i.e. an English company to a French company who sells to another French company? Well, that's a very good question, and there has been a lot of case law on it. It ultimately will come down to following that same structure that I set out. So is there an express choice of law already in the contract? If not, is there an implied choice of law? If not, where does the characteristic performer have their habitual residence? And you're looking at the characteristic performer of the contract in question. You're not looking at the other contracts down the chain. But where that might come into play is when you get to that escape path I was talking about, where you can say, actually, even though the characteristic performer is based, for example, in England, because it's an English company selling to the French company, it might be that the other side wants to argue, actually, this contract is more closely connected to France, therefore French law should apply because of these contracts that surround this, that are up and down the chain. It's quite a hard thing to get a court to agree with. You have to show under the Rome 1 Convention, so that's for contracts entered into after December 2009, you have to show it is manifestly more closely connected with France than England. So it's quite a high standard, but that is one of the things that courts will take into account. So I'm just looking at the other questions. How does the English court actually apply foreign law if the parties have chosen it? This is a good question as well. It's what they do practically is they get a foreign lawyer from that jurisdiction. So say you've got an English court who's going to have to apply Chinese law because that's what the parties have decided in their contract. The English court will say, okay, I need some expert evidence from a Chinese lawyer. to tell me what the law is, and it's proved as a matter of fact. So it can be quite a costly endeavour, because you probably don't just have your lawyers involved on the case in England, but you have to get some expert lawyers as well from another jurisdiction. And we've got one more. I think we've got time for this. How does this work with arbitration? Jonathan, do you want to take that one?
Yeah, sure. So, I mean, in a similar sense to how Sarah was describing earlier, I mean, if there is an express nomination of a governing law, then it will go with that one. But in the situation where no governing law has been nominated, it's a little bit conceptually complicated. I'll try and summarize it. I mean, the end point being that it generally ends up the same. It's just that you probably have to follow a bit of a process of determining the seat of the arbitration, the seat being the city that the court or the arbitration tribunal will be located. For example, the LCIA's default seat will be London, or parties can nominate. And then the arbitration body will generally work out that the laws of the jurisdiction in which the seat is located will apply to the arbitration. So that's just the law that will govern the arbitration, rather than necessarily the substantive dispute. So not there yet. But then that will be the Arbitration Act for England. And then we have the Arbitration Act directs arbitral tribunals to, in lieu of an agreement between the parties, to apply the conflict of law rules which are deemed applicable. And generally, tribunals will, if they are seated in England, will determine this as the English conflict of law rules. And that takes us all the way back up to where Sarah started, and you would then apply, well, now UK and Rome 1, or depending on when the contract was entered into, Rome 1 or the Rome Convention. Okay, thanks, Jonathan. I think time-wise, we'll have to end it there, but we will try and follow up separately with all the other questions that have come in, if we can. And if you do have any further questions, please do get in touch with us. I think our LinkedIn profiles are actually on the next slide. There it is. So you can get to us on there. Yeah, there we are, our beautiful smiling faces. And I believe you can scan those LinkedIn codes, which is very fancy. So yeah, please do get in touch with any other questions. And also if there are any other topics you'd like to hear from us on, any ideas that you have or things that you're facing in your business that you think one of these half-an-hour sessions would be good for, let us know. I think there's a poll coming up, or shortly coming up, with just 2 questions on it, so we'd be very grateful if you could fill that out. And then we've got another one of these contract conversation sessions in 2 weeks' time, which is on privilege. And so hopefully we'll see some of you for that. Thank you very much, and hopefully see you soon.